Hi, my name is Albert No, and I'm an attorney here at Brooks Law Firm. I mainly specialize in personal injury, and today I'm going to talk about a personal injury engagement letter that you, as a potential client, may have been presented by one of the attorneys here at Brooks Law Firm. So I'm just going to go into it directly, and if you want to follow along, that's great. And so the first page consists of the contingency fee agreement, which basically details and identifies the client here, as well as Brooks Law Firm with our addresses here at this office, 10 High Street, and authorizes us to perform legal services for you faithfully and with due diligence, which means that we'll do our best and we'll do good for you. The first paragraph references the claim, controversy, and/or matter. Typically, we put MVA of etc. date, for example, for car accidents. Paragraph 2 talks about the contingencies, so only in the event that we get you a settlement, judgment, verdict, or arbitration award, do you have to pay our contingency fee. This basically sounds exactly like you hear in the commercials, no fee unless we win. It's required for personal injury attorneys, so only in the event that we get you a settlement, judgment, or verdict in your favor do we charge a contingency fee. The third paragraph details how much of the contingency fee will be. It's 33%, or 1/3, standard rate among personal injury attorneys in Massachusetts, and only in the event, and this is very, very, very rare, that we manage to lose at trial and then go to an appeal and win at an appeal, would the rate be 40%. Again, this is just a placeholder. Very rarely does this ever happen, but I felt it would be useful to explain. Fourth paragraph discusses reasonable expenses and disbursements. This basically means attorney expenses during the course of your representation. Now, only in the event if we get you a settlement or if we're disengaged early will you have to pay expenses out of that settlement. The only expenses that Brooks Law Firm charges is filing fees for courts, for litigation, deposition fees also for litigation, as well as travel to the courthouse if it's in person. Again, only the event of litigation. Now, most cases don't make it to litigation, so in those events, the only fees that you would probably have to pay out of settlement is fees associated with getting your medical records and bills. We always try to keep expenses as low as possible. We always try to save as much money for the client as possible. So these expenses are generally very low and kept as low as possible. Again, these expenses are only paid in the event that we do win for you. So if we manage to somehow get you nothing for your case, these expenses that we incur, no matter how much, will eat up the costs of. Paragraph 5 just acknowledges that we will exercise our discretion, our expertise, and our experience in referring you to another attorney in the event that somehow everybody in the firm is deemed incompetent or passes away. Maybe there's a catastrophic accident. If for some reason all the attorneys are unable to represent you anymore, we can try to refer you to another attorney who can. It's sort of like a catch-all in case everyone for some reason passes away or something. Paragraph 6 just allows us to assert a lien, basically for our reasonable fee or portion thereof in the event we're discharged early from representation. Basically, that means if you decide to go with another attorney, we split the 1/3 fee with that attorney. You're not paying double fees, and we don't seek anything more than what we reasonably put into the case. Paragraph 7 talks about a discharge prior to representation. Again, if for some reason you decide to go with another attorney, go to another firm, anything, we would be entitled to try and recover our reasonable portion of that fee. Again, it's not a double fee. We only try to recover what's fair. Paragraph 8 talks about the steps that Brooks Law Firm uses to store your electronic files and information. Every step is taken to protect your privacy. We keep it secure in the firm behind 2 layers of encryption. That basically means that there's a lot of protection with regard to your electronic files. Most of the files that we keep from you are electronic, so in the event that we do have paper files, we keep those locked in a safe. We dispose of your files, the physical ones anyways, within 10 years as required by the model rules of professional conduct. Paragraph 9 basically talks about the types of mediums that we store, which I just mentioned, paper and electronic. We'll maintain confidentiality, although sometimes data breaches can happen, as we've known in recent times. We'll do everything in our power to avoid data breaches. We've never had one yet, knock on wood, but in the event that something does happen, we'll do everything in our power to keep your information safe. Paragraph 10 talks about electronic signatures. As we live in a digital age, electronic signatures make things more convenient for you. So we might ask you to use DocuSign or VineSign to sign things electronically rather than having you come in all the time. And finally, paragraph 11 just talks about the model rules of professional conduct. Basically means that we will be ethical, we will advocate zealously for you, and we will communicate well and be competent in our representation for you. The page 3 of 5 is the express written authorization of representation. That just is something that we show to third parties, such as insurance companies or medical providers, to say that you've hired us to represent you. Page 4 of 5 is the authorization to endorse checks. This basically allows us to have the insurance company write a settlement check out to us. We'll do all of the accounting work for you, take out the fees, medical payments, expenses, etc., and write you a check for the remainder. And the 5th page is a limited power of attorney. So only in the event, and this is similar to the first page about all of the attorneys dying or going missing for whatever reason, if you for some reason pass away or go missing and we can't reach you, close to the 3-year statute of limitation for personal injury cases, we have the power, the very limited power of attorney to settle your case in your interest. We'll always try to get as much as we can for your case, and we'll basically hold on to the money in our IOTA account, which is a special trust account for attorneys, until we can find you or find your heirs. We'll always try to look for you. We'll send out letters to you. We'll try to call you. We'll try to see if you have any aliases or heirs or alternate addresses. So this limited power of attorney is very, very limited in the sense that we've never really had to use it, and only in the event where if we can't find you would we need it. Finally, on the very last page is an authorization to use or disclose protected health information. This document is something we use to gather your medical records and bills. Under federal HIPAA laws, that's just what's required. So we just need your signature on that to pursue your personal injury case for you. And yeah, that's basically it. Thank you for sticking with me almost 10 minutes on explaining this agreement. Of course, if you have any additional questions about it, feel free to ask your attorney at Brooks Law Firm about it, any specifics that you may have. I hope I did a good job explaining it to you. And if you have any questions about the contingency fee agreement, or if you'd like to pursue a personal injury case with us, feel free to reach us at 617-245-8090. Thank you.